Administrative law might seem complex, but it's a crucial part of our legal system. It shapes how public authorities operate and affects our daily lives in more ways than we often realize. Stay tuned as we unveil the significance, key concepts, and real-world applications of administrative law. Now, let's delve into the heart of our topic. Administrative law ensures fairness, transparency, and accountability in decisions made by public authorities. It provides a framework for individuals and businesses to interact with the state justly. At its core, administrative law safeguards against arbitrary decision-making, protecting individual rights. Understanding administrative law is essential for navigating government agencies and public bodies. Administrative law permeates everyday life, from renewing a driver's license to boarding a plane. It sets standards and ensures compliance in areas like public safety, food, and education. Businesses must navigate administrative requirements for licenses and permits. Understanding these requirements is crucial for business success. Key concepts in administrative law include the duty of fairness, jurisdiction, and natural justice. The duty of fairness mandates procedural fairness in decision-making. Jurisdiction refers to the legal authority of an administrative body. Natural justice encompasses the right to a fair hearing and an unbiased decision. Legislative authority in Canada is divided between federal and provincial governments. This division determines which level of government can create administrative bodies. Federal bodies handle national matters like immigration, while provinces manage local concerns like education. This balance respects both national unity and regional diversity. The Constitution Act, 1867, shapes the relationship between administrative tribunals and courts. It empowers the federal government to appoint judges to superior courts. The Supreme Court of Canada ensures tribunals do not encroach on court jurisdiction. Tribunals can have adjudicative powers, but must not undermine superior courts. Federalism creates a complex web of administrative bodies at both federal and provincial levels. Coordination is essential for smooth administrative law across jurisdictions. Environmental protection often requires collaboration between federal and provincial authorities. Balancing national standards with regional diversity is a constant challenge. The Canadian Charter of Rights and Freedoms impacts administrative law. Administrative decisions must align with charter rights like life, liberty, and security. The Charter emphasizes fairness and procedural safeguards in decision-making. The duty of fairness is rooted in the principles of fundamental justice. Challenging administrative decisions is crucial for fairness and accountability. The two primary avenues are statutory appeals and judicial review. Statutory appeals are governed by specific legislation. Judicial review allows courts to review the legality and fairness of decisions. Statutory appeals provide a structured pathway for challenging decisions. Provisions outline which decisions are appealable and the process for appeals. Some statutes allow for a full rehearing, while others limit appeals to questions of law. Exhausting statutory appeals is often required before seeking judicial review. Judicial review safeguards against arbitrary or unlawful exercises of power. It allows courts to ensure administrative bodies act within their statutory authority. Grounds for judicial review include exceeding jurisdiction and procedural unfairness. Judicial review is available even without a statutory right of appeal. Statutory appeals and judicial review ensure administrative action is lawful and fair. Appeals derive authority from the legislature, while judicial review is rooted in court jurisdiction. They often intersect, with parties seeking judicial review after statutory appeals. This hierarchy ensures higher-level decisions are scrutinized by courts. Standing determines who can challenge administrative decisions in court. It ensures challenges are brought by those with a genuine interest. The two-pronged test for standing includes sufficient interest and no other means of bringing the issue to court. This balance prevents frivolous litigation while ensuring access to justice. Direct interest and its importance. The requirement of a direct interest is central to the concept of standing in administrative law. This requirement ensures that individuals and groups seeking to challenge administrative decisions are not mere bystanders, but rather have a stake in the outcome of the litigation that is sufficiently direct and personal to warrant the court's intervention. In essence, the applicant must demonstrate that the administrative decision has, or is likely to have, a tangible impact on their legal rights or interests. Determining whether an applicant has a sufficiently direct interest is a fact-specific inquiry that depends on the nature of the administrative decision, the nature of the applicant's interest, and the relationship between the two. For example, an individual who is directly affected by a zoning bylaw that prohibits them from building a certain type of structure on their property would likely be found to have standing to challenge that bylaw. Their interest is direct, personal, and adversely affected by the decision. Conversely, a group with a general interest in environmental protection would not necessarily have standing to challenge the same zoning bylaw simply because it could have some impact on the environment. Their interest, while legitimate, is not sufficiently direct or specific to the decision at hand. To establish standing in such a case, the group would need to demonstrate a closer connection between the bylaw and its specific mandate or activities, such as showing that the bylaw would directly impact a conservation area it manages. Advocating for broader concerns. Recognizing that some matters of public importance might not always find a suitable individual or group with a direct interest to bring a legal challenge, Canadian courts have developed the concept of public interest standing. This exception to the general rule of direct interest allows individuals or organizations to challenge administrative decisions that raise issues of broader public concern, even if they cannot demonstrate a direct and personal impact on their own rights or interests. Public interest standing is granted sparingly and only in exceptional circumstances. The courts have established a three-part test to determine whether to grant public interest standing. First, the case must raise a serious issue of general public importance. Second, the applicant must have a genuine interest in the issue and be a reasonable and responsible advocate for the public interest. Third, there must be no other reasonable and effective means of bringing the issue before the court. A landmark case in Canadian administrative law, Downtown Eastside Sex Workers United Against Violence v. Canada, Attorney General, exemplifies the application of public interest standing. In this case, a group of sex workers and their advocacy organization sought to challenge the constitutionality of Canada's prostitution laws. Despite not having a direct interest in the traditional sense, the Supreme Court of Canada granted them public interest standing, recognizing the importance of the issue and the group's unique position to bring the challenge forward. Expanding access to justice. The evolution of standing rules in Canadian administrative law reflects a broader trend towards expanding access to justice and ensuring that individuals and groups have meaningful avenues to hold public authorities accountable. While safeguarding against frivolous or vexatious litigation remains a concern, courts have increasingly recognized the importance of allowing public interest litigants to bring forward challenges that raise significant legal and societal issues. The recognition of public interest standing has been particularly impactful in areas such as environmental protection, human rights, and social justice. In these areas, traditional standing rules often posed insurmountable barriers to bringing legal challenges, as the harms at stake were often diffuse and difficult to quantify in terms of individual rights or interests. Public interest standing has provided a crucial pathway for advocacy groups and concerned citizens to raise awareness about these issues and challenge government action that they believe to be unlawful or contrary to the public good. However, challenges remain in ensuring equitable access to justice in administrative law. Public interest litigation can be expensive and resource-intensive, and not all individuals or groups have the means to mount such challenges. Moreover, the legal complexities of standing rules can be daunting, and navigating these rules without legal representation can be difficult. As such, ongoing efforts to simplify procedures and provide legal aid for public interest litigation are crucial to ensuring that the doors of justice remain open to all. Exceeding jurisdiction, acting beyond authority. One of the fundamental principles underpinning administrative law is the concept of jurisdiction. Administrative bodies, being creatures of statute, derive their authority from the specific legislation that creates them. This legislation sets out the boundaries within which these bodies can operate, outlining their powers, duties, and the scope of their decision-making authority. When an administrative body acts outside of these defined boundaries, it is said to have exceeded its jurisdiction, rendering its decision invalid. The principle of jurisdiction ensures that administrative bodies do not overstep their legal mandate and encroach upon areas reserved for other decision-makers, including the courts. It acts as a safeguard against arbitrary or capricious exercises of power, ensuring that administrative decisions are grounded in the rule of law and subject to appropriate oversight. The courts, through the process of judicial review, play a crucial role in policing these jurisdictional boundaries, ensuring that administrative bodies remain within the limits of their statutory authority. Challenges based on exceeding jurisdiction often hinge on the interpretation of the enabling legislation. Courts are tasked with determining whether the administrative body's actions fall within the scope of the powers granted to it by the legislature. This involves scrutinizing the wording of the statute, considering its purpose and legislative history, and examining how the provision in question has been interpreted in previous cases. The courts, in essence, act as guardians of the legislative intent, ensuring that administrative bodies remain faithful to the powers bestowed upon them. Procedural fairness, ensuring a fair hearing. The principle of procedural fairness, also known as natural justice, lies at the heart of administrative law. This fundamental principle dictates that individuals affected by administrative decisions are entitled to a fair and impartial process. It ensures that decisions are made in a just and equitable manner, safeguarding against arbitrary or capricious outcomes and upholding the integrity of the administrative justice system. The duty of fairness is not a static concept, but rather a flexible principle that adapts to the specific circumstances of each case. The level of procedural fairness required in a given situation depends on a number of factors, including the nature of the decision, the nature of the statutory scheme, the importance of the decision to the individual affected, and the legitimate expectations of the parties involved. In some cases, procedural fairness may require a full-blown oral hearing, while in others, written submissions or a more informal process may suffice. At its core, procedural fairness encompasses several key elements. Firstly, individuals have the right to be heard, which includes the right to receive adequate notice of the proceedings, the right to know the case against them, and the right to present their own evidence and arguments. Secondly, individuals have the right to an unbiased decision-maker, meaning that the person or body making the decision must be free from actual bias or the appearance of bias. Finally, in most cases, individuals have the right to reasons for the decision, which allows them to understand the basis for the decision and to determine whether grounds for appeal or judicial review exist. Misinterpreting legal principles. Administrative bodies interpret and apply legal principles within their expertise. Misconstruing a legal principle is an error of law, grounds for challenging decisions. Errors can include misinterpreting statutes, applying wrong tests, or ignoring principles. Courts correct these errors through judicial review, ensuring adherence to the rule of law. The standard of review determines the deference courts give to administrative interpretations. Courts may apply correctness or reasonableness standards based on the case. Decisions unsupported by evidence. Administrative bodies make decisions based on a variety of factors, including evidence presented by the parties, expert opinions, and their own specialized knowledge. The quality and reliability of this evidence play a crucial role in ensuring that administrative decisions are sound, justifiable, and consistent with the principles of fairness and rationality. When an administrative body bases its decision on erroneous or insufficient evidence, it commits an error of fact, which can be a ground for challenging the decision. Errors of fact can manifest in several ways. An administrative body may misapprehend the evidence before it, draw unreasonable inferences from the evidence, or base its decision on speculation or conjecture, rather than concrete facts. These errors can undermine the legitimacy of administrative decision-making, leading to outcomes that are arbitrary, unfair, or simply wrong. The courts, through judicial review, provide a mechanism for correcting these errors, ensuring that administrative decisions are grounded in a sound evidentiary foundation. The standard of review applied by the courts when reviewing administrative decisions for errors of fact is generally deferential. Courts recognize that administrative bodies, particularly those with specialized expertise, are often better positioned to weigh evidence and make factual findings. As such, courts will typically only overturn an administrative body's factual findings if they are unreasonable, in the sense that no reasonable decision-maker could have reached the same conclusion based on the evidence before it. This deferential standard of review reflects the principle of judicial restraint, acknowledging the expertise of administrative bodies and the importance of allowing them a certain degree of latitude in making factual determinations. Upholding the rule of law. Administrative law is a cornerstone of the Canadian legal system, embodying fairness, transparency, and accountability. It regulates the powers of the administrative state, ensuring respect for individual rights and promoting the public good. Administrative law balances efficient governance with the protection of individual rights. It provides mechanisms for challenging administrative actions, holding power accountable. This accountability maintains public trust in government institutions. Administrative law shapes interactions between individuals, businesses, and the state. From licensing to healthcare and immigration, it provides a framework for government actions. Navigating the future of administrative law. Administrative law is a dynamic field adapting to society's changing needs. Emerging challenges like technological advancements and climate change will bring new questions. Increasing specialization in decision-making is a key challenge. Balancing expertise and accessibility is crucial for public trust. Administrative law must reflect inclusivity, equity, and reconciliation. Addressing systemic barriers and promoting culturally sensitive approaches is essential. By embracing innovation and upholding principles, administrative law can promote fairness and accountability.